everybody, welcome to iExamB's Legal Beat. This is Amrita, your law faculty here at iExamB. Embrace the iExamB learning experience with us. If you're preparing for any competitive examination after your law, like SEBI Graded Legal Officer, IBPS SO Law Officer, and various other exam opportunities, then you're at the right place. At Legal B, we keep on providing you different content as well as strategic preparation videos. Even we have online courses available on www.iexamb.com for all these exams. इन सारे courses के आप demo activate करके देख सकते हैं. कोई भी doubts या queries हो, you can reach out to us, write us an email on hello@iexamb.com or call us on this number 920552408. Download our app for 50% faster job preparation. I had started a series of important MCQs and I am going to continue with this series. This is the 10th video of my series. इसमें मैं आपके साथ क्रेडिट इंफॉर्मेशन कंपनीज रेगुलेशन एक्ट के बारे में बात करने वाली हूँ. वी आर गोइंग टू डिस्कस MCQs फ्रॉम दिस एक्ट. Before we go ahead, Big B Days sale announcement I would like to make to you all. This is ongoing offer which is available on various courses individually, and there is 70% off on all the online courses at iExamB. So enroll now. These are the biggest discounts of the year. In which year did the Credit Information Companies Regulation Act 2005 come into force? 15 May 2005, 31st October 2005, 14 December 2006, 14th August 2006, 24th December 2006. Now they have also given you the date over here. So like that it becomes more accurate answer. So you have to remember accordingly. Correct answer is C. 14 December 2006 is when actually the act was implemented. And it extends to the whole of India. As per Credit Information Companies Regulation Act 2005, the Reserve Bank may by notification increase the minimum amount of authorized capital of every credit information company to an amount of 50 crores, any amount not exceeding 15 crores, any amount not exceeding 50 crores, such amount as it may determine after consultation with the central government, either A or D. Correct answer is C. Any amount not exceeding 50 crores. Section 8 clause 1 deals with the requirement as to minimum capital. The proviso clause covers this point, not exceeding 50 crores. So the correct answer is C. According to Credit Information Companies Regulation Act, specified user means credit institution, credit information company, person or institution as the RBI may specify, all of the above, both A and C. Correct answer is D, all of the above. Section 2 clause L, any credit institution, credit information company being a member under section 15 clause 3 and includes such other person or institution as may be specified by regulations made from time to time by the RBI for purpose of obtaining credit information from a credit information company. According to Credit Information Companies Regulation Act, no person shall have access to credit information in the possession or control of a credit information company or a credit institution or a specified user unless the access is authorized. Access is authorized by any other law for the time being in force. Authorized by the Act was the first option. Third one, any court or tribunal directs to do so. All of the above. Either of the three, A or B or C. Again, the correct answer is E. All these three conditions are possible over here, in which we can say that the access can be authorized by this Act also, authorized by any other law also, or any court or tribunal also can direct the same. Section 22 clause 1 talks about unauthorized access to credit information. What is the punishment in case of contravention or obstruction or default in complying any requirements of this Act or any rule, order made or direction issued thereunder if there is no specific provision made under this Act? The punishment will be, without specific provision, punishment will be fine not exceeding 1 crore rupees, fine which may extend to 1 lakh rupees, fine which may extend to 1 crore rupees, punishable with fine which may extend to 1 lakh rupees, and where a contravention or default is a continuing one, with a further fine which may extend to 5,000 rupees per day, during which the contravention or default continues. Punishable with fine which may extend to 1 crore rupees, and where a contravention or default is a continuing one, with a further fine which may extend to 15,000 rupees for every day during which the contravention or default continues. Correct answer is the D option. Section 23 clause 4 covers this point and provides for this punishment. Section 23 covers the offences and penalties. As per this act, I would hereinafter call it as the act, any credit information company or institution or specified user willfully performing any act or engaging in any practice in breach of any of the principles under section 20 shall be punishable with a fine not exceeding 1 crore rupees, fine which may extend to 1 lakh rupees, fine which may extend to 1 crore rupees, fine which imprisonment for a term which may extend to 1 year and shall be liable to fine, none of the above. Correct answer is A, with fine not exceeding 1 crore of rupees. Section 23 offences and penalties. Clause 2 covers this point. Not exceeding 1 crore rupees. Which section of CIC deals with the power of Reserve Bank to give directions? Section 7, 8, 9, 11, 21. So, first the question is whether Reserve Bank has the power to give directions, and if yes, then under which section? Now यहाँ पे none of the above option में नहीं है, but कई बार ऐसा भी हो सकता है कि वो none of the above option में देके आपको confuse कर दे that whether the RBI is having any power to give directions or not. Correct answer is D. Section 11 covers this power of Reserve Bank to give directions. On whose direction an inspection can be conducted of any credit information company, institution and specified user as per this act? Who can give these directions? Reserve Bank, central government on being directed by competent authorities under the act. Reserve Bank at any time may and on being directed so to do by the central government. Central government at any time may and on being directed so to do by the Reserve Bank. Reserve Bank may at its discretion and depending on the circumstances, none of the above. Correct answer is B. Reserve Bank at any time may and on being directed so to do by the central government. Section 12 clause 1 talks about inspection of credit information company, credit institution and specified users. As per the act, the minimum paid up capital of every credit information company at any time shall not be less than 75%, not less than 75% of the authorized capital, shall not be less than 75% of the issued capital, may not be less than 75% of the subscribed capital, may not be less than 75% of the issued capital. Correct answer is C. It shall not be less than 75% of the issued capital, which is covered under section 8 clause 3. Minimum paid up capital of every credit information company at any time shall not be less than 75% of the issued capital. 10th point, authorized capital of every credit information company as per the act shall be a minimum of 10 crores, minimum of 30 crores, maybe a minimum of 30 crores, shall be as may be notified by RBI from time to time, none of the above. Answer is B, shall be a minimum of 30 crores. Section 8 covers requirement as to minimum capital. Clause 1, authorized capital of every credit information company shall be a minimum of 30 crores. An appeal against the order of RBI may be preferred to dash under the CIC Regulation Act 2005. Central government, no such appeal can be made. Any authority or tribunal designated by the central government, both A and B, either A or C. Correct answer is E. Either it will be A or it will be C. Central government or any authority tribunal designated by the central government. Appeal against the order of Reserve Bank is covered under section 7, which covers this point. Who can appeal to whom? Central government or any other authority or tribunal which may be designated by the rules made by central government. And time period भी आपको पूछा जा सकता है, that is 30 days. Under Credit Information Company Regulation Act, credit information can be commenced or carried on only after obtaining a certificate of registration from the dash. RBI, central government, no requirement as such, competent authorities, credit information company. So this certificate of registration, whether it has to be given, whether it is required, and if it is given, then who is supposed to give it? Correct answer is A, RBI. Section 3 covers prohibition to commence or carry on business credit of credit information. Save otherwise as provided in the Act, no company shall commence or carry on business of credit information without obtaining a certificate of registration from the Reserve Bank under this Act. The word borrower as per Credit Information Act means any person who has been granted loan or any other credit facility by a credit institution and includes a client of a credit institution. Any person who has been granted loan and any other credit facility by a credit institution and includes a client of credit institution. Any bank or banking institution or a public financial institution. Both A and C, none of the above. Correct answer is A. Any person who has been granted a loan or any other credit facility by a credit institution and includes a client of a credit institution. Section 2 clause B covers Credit Information Act. Borrower definition means any person who has been granted loan, any other credit facility by a credit institution and includes a client of a credit institution. Which section of the Act deals with grant of certificate of registration? 5, 6, 7, 24, none of the above. Somewhere you have to study and remember the section numbers as well if it's really important. Section 5 covers about the grant of certificate of registration. This is the entire first clause A, B, C I have covered over here. You can pause the video and read the entire section. You can also download the PPTs along with all the videos and refer all these questions for the practice of the series. Every credit information company in existence on the commencement of Credit Information Companies Regulation Act 2005 shall before expiry of 30 days from the commencement apply in writing to RBI for obtaining a certificate of registration under this Act. Again, before the expiry of 6 months. Now everything is same, just the time period is changed over here. Third option, apply in writing to RBI for obtaining a certificate of registration. Make an application to the central government. None of the above. So after this Act has come into existence, every credit information has to do what procedure? Before expiry of 6 months, means within 6 months of the commencement of the Act itself, they had to apply in writing to RBI for obtaining a certificate of registration under this Act. Section 4 clause 2 covered this particular point. And this is about the companies that were in existence at that time, credit information companies. Now obviously we have the Act in existence, so as it is whenever the company is established, at that time only it will be incorporated. So this is all from the Act. Any other doubts, queries, reach out to us in the comment section of the video. Prepare 50% faster with us at iExamB. Download our app from Google Play Store and check out the full course access available even on our app and also in offline mode. Thank you everybody. Have a good day.